For our next case, we have the State of New York et al. Versus Steven Mnuchin in his official capacity as the head of the Treasury and the United States Department of Treasury. So this deals with a change in tax law that was a pretty substantial change that President Trump signed when he came to office. It had some huge impacts on the ability of states to deduct certain things and made states essentially more responsible for states' costs. So we're going to read some of this decision that deals with this and see what the issues are and see what the court has to say. So it'll be pretty interesting. On December the 22nd, 2017, President Trump signed into law the Tax Cut and Jobs Act, which made several substantial amendments to the tax code. Among other things, the act took novel steps of placing an upper limit on the amount a taxpayer may deduct from his federal taxable income to offset the sums she's paid to certain state and local taxes. So before, when you had state and local taxes, you could write those off on your federal taxes, but they put a limit on it, on how much you could write off. So there's a cap now on these kinds of things. So you may not be able to write off all your taxes, so that is potentially an issue. So let's see what happens next. Concerned that the introduction of the cap could impair their ability to pursue their own tax policies, 4 states filed suit against the federal government for alleging that the caps violates federalism principles that undergird the Constitution. The government has moved to dismiss, contending the court lacks jurisdiction, and the states have failed to state a claim. States, in turn, have filed cross motions. For reasons to file, the government's motion to dismiss is granted, and the state's cross motion is denied. So the federal tax plan is constitutional, and the states lose. The states first argued the Constitution contains a limit on the federal tax power that would bar any congressional effort to tax a substantial portion of the sum the taxpayer has paid towards state and local taxes. While acknowledging that no such limitation appears in the text, the states argue limitation can nonetheless be inferred from essential postulates that are part of the history and structure. That's reaching. In particular, the states recount the deduction's extraordinarily long and consistent history and urge the court to conclude that Congress constitutionally grounded views about state sovereignty and the limits of federal taxing power that had been driven into a near total deduction in every prior version of the tax law. The states are correct that the cap is in some ways unprecedented. As the court has already explained, the availability of an uncapped deduction for state income and property taxes has been a mainstay of federal income tax since the tax's inception. Certainly, as the government points out, Congress has over the years altered what sort of state and local taxes are eligible for deduction and made changes to the structure of the tax code that, as a practical matter, have limited the amount of state and local tax liabilities. The government, though, has identified no prior statute that directly limits the deduction for state and local taxes to a specified dollar amount. So this is a new thing in kind. They're putting a firm cap on it where they didn't do that before. The states are further correct that there's no constitutional text speaking to a precise question. The courts may, in seeking an answer, seek, among other things, a historic understanding and practice. So, for example, in Prince v. United States, the Supreme Court, when invalidating a federal law that required state and local enforcement officers to perform background checks on potential handgun purchasers, the court found it relevant that compelled enlistment of state officers for the administration of federal programs was unprecedented. In Free Entertainment Fund versus Public Accounting, the Supreme Court cited the historic novelty of a statute that placed unprecedented restrictions on the president's ability to remove certain executive officers as a sign of unconstitutionality. Mere legislative novelty, however, is not necessarily fatal. Even if a historic practice tends to negate the effect of an asserted government power, that alone is not conclusive. Rather, the courts look to historic practice to inform their understanding of structural limitations that ultimately arise. In Prince, then, the novelty of law was instructive only so far as it clarified how the Constitution enshrined the division of power that has historically been viewed. And in Free Enterprise Fund, the court considered the past legislative practice not for its own sake, but only in aid of understanding the scope that the Constitution invades in precedent. So history is only relevant to understand the underlying text and underlying structure. It's not a limitation unto itself. It's only valid for understanding how these texts operate. So that seems perfectly clear. Instead of looking at the cap's novelty alone, this court must ask where the fact that Congress has not previously imposed such a cap, a structural limitation built in the constitutional plan. And this is where the states run into trouble. The Supreme Court has held Article 1, Section 8, from which the federal government derives its power to lay and collect taxes, is exhaustive and embraces every conceivable power of taxation, including the power to lay and collect income taxes. Accordingly, Congress holds plenary power under the Constitution to tax income and grant exemptions from that tax. Plenary power is basically absolute power. It is unilateral, absolute, unquestioned, unchecked power. Plenary power is God. So Congress holds God power to tax income and grant exemptions from the tax. Congress can do what it likes. The plenary power knows no restriction except one that arises in or around the Constitution. It is the power of God. You can do anything you want in this area. The states have cited no constitutional principle that would bar Congress from exerting its otherwise plenary absolute power to impose an income tax without this deduction. In the main, they rely on the notion the 10th Amendment preserves the state's power to tax all property within their limits. True as far as it goes. The states can tax too. And so it bars improper interference with state taxing power. Potentially true to the state to the extent you said a state cannot tax. That even uncapped that deduction, though, the states were free to exercise their tax power however they wish. That is the fatal aspect here. So even though there's this cap on the amount of deduction, the states are not limited. They can charge any amount of tax they want. It just means that the people can't write off a certain amount on their federal taxes. So the states still have power to have any tax power they want. Now, of course, the people that are limited by this tax are going to pressure their states to lower their taxes, but that's neither here nor there. The states ultimately have the power to do as they wish. To be sure, the cap, like any other feature, makes certain state policies more attractive than others as a practical matter, but this bare fact that otherwise valid law necessarily affects the decisional landscape in which they choose how to affect their own sovereign authority hardly means the law infringes. Right. So when one sovereign does something, it might necessarily impact the choices you're going to make. If I do something, it might impact the choices you're going to make. My free decisions impact your free decisions. You're free to choose, I'm free to choose. And our free decisions might impact each other. It might impact what we want to do. It might impact our incentives. But we're still free to choose. The fact that we're going to make different decisions is irrelevant. We're still free to choose. And that's exactly what they're saying here. Look, guys, the federal government has the ability to tax. They can tax however they like. You have the ability to tax however you like. Now, certainly these policies are now more attractive than they were before. This may be Congress's goal, in fact. They may be wanting to make it more attractive. But whether it's their goal or not, they have the ability to do it. And so if you're going to change your policies, it's your decision to make. It's no longer as attractive to you. Doesn't mean it's your call. Do what you want, but we're free. The Supreme Court's opinion in South Carolina versus Baker dispels any remaining doubt on this point. In Baker, the court rejected the claim that Congress has overstepped its constitutional authority when it eliminated a long-standing exemption for interest on state interest-bearer bonds. Despite the historic fact it always exempted bonds from taxation began with the very first statute, the court rejected the idea the exemption had been frozen. Concluding nothing in the Constitution itself mandated the long-standing exception, the court perceived no constitutional flaw. Yeah, so basically, just because it's always been true doesn't mean it will always continue to be true. Congress does what Congress wants to do. And just because it's always been this way doesn't mean it has to be this way. Congress gets to choose its laws. Congress gets to write laws, and they have plenary, absolutely godlike authority in their tax authority. When it comes to income tax, they can structure it any way they want. And so the fact it's always been this way, well, it's no longer this way. So that's the way it's going to be now. This case governs here. As in Baker, the parties seek to impose a limitation on the plenary power. In this case, it made a strong showing Congress has historically exempted a certain income. Yeah, it's historically been exempted. You're right. But also, like in Baker, those parties have failed to identify any persuasive basis for reading the exemption in the Constitution. Yep, it's long been true. Doesn't mean it's constitutionally required. Makes sense? If anything, Baker presents a better opportunity for recognizing constitutionally rooted limitation than this case does, and this is true for two reasons. First, Baker addressed past legislative practice that was consistent with historic practice upon which the states rely on here. Prior to the law issue, Congress had never before taxed interest earned on state-issued bonds, making the challenged law a stark historical outlier. Here, however, although a direct cap on deduction towards sum paid by a state is a novelty, Congress has previously imposed a limitation for state and local sales taxes. So there is a parallel where there's been limitations on sales taxes, and now they're doing the same thing when it comes to income taxes. That makes sense. In the past, moreover, indirectly limited deductions altogether for certain payers. So they have previously limited in this exact domain and in parallel domains, just never by a hard cap, and now it's a hard cap. So what? In 1990, for example, Congress enacted the PEACE limitation, under which taxpayers with adjusted gross incomes earning a certain threshold were required to apply to a specific reduction of total amount. And the PEACE limitation has been upheld as constitutional over the objections that it seizes Congress's authority by effectively limiting the deduction. No, it doesn't. Second, the relevant historical record in Baker betrays expressive legislative doubt as the constitutional limiting of deduction issue. As the court has explained, the issue of whether the 16th Amendment allows Congress to tax income on state-issued bonds was a sort of explicit uncertainty during ratification debates. The states point to no comparable evidence that shows these deductions have historically been seen as constitutionally required. Legislators, of course, have accepted the uncontroversial proposition that Congress may not directly interfere with states' exercise of sovereign tax authority. But as said out above, the cap does not create such an interference. While the states highlight legislative statements that reference this deduction in combination with states' rights, these sparse, ambiguous references to Federalist principles fail to demonstrate a widely held, longstanding view that the uncapped deduction for every past income tax, Congress has been responding to a constitutional imperative rather than an accommodating policy choice. Yes, we've chosen to accommodate you in the past, and we don't want to anymore. Accordingly to one of the founding sources the states have cited, took full view that dual state federal taxation under the Constitution would lead to improper accumulation of taxes on the same object. The result would be a mutual inconvenience not arising from superiority or defective power on either side, but from an injustice exercise of authority. It then expressed a hope that the mutual interests would dictate a concert in this respect. The court recognizes the cap in novel, but the states have failed to persuade that the novelty alone is an excess of power, and I would agree that it is not an excess of power. Unable to establish the dollar cap in the deduction as unlawful per se, the states next pursue a narrower ground of argument that takes aim at the specific cap here. Put briefly, the states argue the purpose and effect of this cap is to coerce certain target states into bringing their tax policies in line with federal government policies, and this sort of target coercion the state maintains violates the Constitution. So this is definitely a thing. There is definitely a limit on when it comes to coercion. The case on point is South Dakota versus Dole, dealing with federal authority on taxing of highways. But yeah, there is definitely a limit for unconstitutional coercion. Let's see what the court says. The state's coercion argument rests on the principle the 10th Amendment restricts Congress' ability to directly or otherwise motivate the states to regulate in a particular field or particular way. Most fundamentally, Congress cannot simply commandeer the legislative process by directly compelling them to enact. That is definitely true. They cannot directly impose on the states. And as Congress may not directly compel the states, it exceeds the scope of its own constitutional authority if it indirectly coerces a state. The state contends this principle applies here. Although they've not identified any specific federal policy the cap is designed to coerce them into adopting, and that's a pretty big issue. If you can't identify what it's designed to do, right, it's not coercive. Unlike, for example, the drinking age issue, which was South Dakota v. Dole, when they said the drinking age should be 21. It's pretty easy to identify the issue. They want us to change the drinking age. Here it's like we can't identify what they're trying to do. The states allege the cap constitutes an effort to disincentivize them in general terms from imposing a high tax rate. Worse yet, they go on, this coercive effect is no more incident of an otherwise innocent piece of legislation. To the contrary, they argue Congress intended the cap would effectively compel certain disfavored, high-taxing states to alter their tax policies. Thus, the states conclude the cap works to an unlawful coercive effect in violation of the 10th Amendment, but does in disparate manner that violates constitutional principles. As an initial matter, the court declines to speculate on motives in passing the act. As well they should. They don't look to motives. They look to the law and look to what the law actually requires. We don't look to motives. We look to what it does. And that goes both ways, incidentally. We don't look to good reasons or bad reasons. We look to the law. Even assuming favorably the states that Congress enacted the hope in the case of promoting states, the court's opinion in South Dakota versus Dole, I told you it was the prominent case on point, and now they're citing it. Makes it clear that an otherwise valid federal law does not offend the Constitution simply because it seeks to affect state policies. In Dole, the court rejected the claim that Congress had exceeded its constitutional authority by directing the Secretary of Transportation to withhold highway funds from any state that authorized anyone younger than 21 to drink. Even assuming Congress had no power to regulate drinking ages directly, the court held, Congress nevertheless had constitutional authority to act indirectly under its spending power to encourage uniformity. The court's reasoning was straightforward. Beginning with the established principle, the Constitution gives broad authority to authorize the expenditure of public monies for public purposes. The court saw no constitutional problem with Congress's choice to use that power to give a relatively mild encouragement to the states to enact minimum drinking age. This was so, the court reasoned, because even if the challenge law favors certain state policies, the ultimate decision of where to set the drinking age remained the prerogative of the states, not merely in theory, but in fact. Yes, even today, a state can change its drinking age to under 21. It just gives up certain highway funds to do so, but it is, in fact, a choice a state can make. The same reasoning applies here. The federal taxing power, like the spending power, gives the federal government considerable influence even in areas where it cannot directly regulate. Yes, money is an influence, as you would expect. Just as Congress may impose conditions on federal spending in order to incur federal federally preferred policies and may also influence states by enacting tax on activity it cannot authorize, forbid, or otherwise directly control. Thus, the tax context, no less than spending context, a court will typically not inquire into motive. Nor have the states shown any legislative intent that would be relevant, even if they claim Congress intended for the cap to adversely affect disproportionately in certain states. Article 1, Section 8 permits Congress to enact a tax that does not fall equally or proportionally on every state as long as it operates with the same force and effect everywhere it's found. The law applies equally to all state and local taxes, and the disparate nature would not ordinarily raise constitutional concern. The states, of course, contend the cap violates an independent constitutional privilege as held in Shelby County, namely that all states enjoy sovereignty, but this case is not on point. In that case, the court invalidated a statutory scheme that required states to obtain federal permission from enacting law-related voting, a requirement the court viewed as an extraordinary departure from traditional coercive relationships. That scheme bears no relationship to this cap, which applies to every state's taxpayer and does not require any state to beseech the federal government for permission. Put simply, nothing in Shelby County suggests equal sovereignty principle bars Congress from using its taxing power. To assert the coercion claim, they must look to the cap's effects rather than the aim it was achieving. Specifically, the court considers whether it has sufficiently alleged the cap goes beyond a mild encouragement. In arguing the cap will indeed have an impermissible coercive effect, the states point to a number of facts they characterize as undisputed. First, they claim that taxpayers will pay billions of dollars in additional federal income tax because of the cap, relative to what they would have paid had it been enacted without the cap. Second, the states claim the cap will make home ownership in the states more expensive and decrease the value of the real estate by billions of dollars, while New York State in particular predicting this drop in property values will cause a large lower spending value, reduced in-state sales, and significant in-state job losses. Finally, the states anticipate the cap will cause them to lose $1 million of real estate tax revenue. Ultimately, though, the court cannot conclude these harms, even if real, are sufficient to say it's coercive. First, the estimates of how much it impacts are based on flawed assumption. In making these estimates, the states have compared their taxpayer situation under the Act as it's been enacted to a taxpayer situation would be if Congress had passed the Act without the cap. There is no reason to believe, however, that the Act would have looked anything like the enacted version that Congress had been able without the cap. The states, of course, respond that a court concerning the constitutionality of provision necessarily looks to that provision's effect, not the effects of the entire enactment. But the general proposition carries a little water here. The grave moment of states' concern, after all, is that the states' effects will be so severe, the states will be compelled to change their policies that were in effect at the time of the enactment. It makes no sense for the court in assessing that claim to disregard the developments that may have blunted the effect. Second, even if the court follows the states in isolating the effects of the cap from all their effects, the states have not plausibly alleged the caps are so harmful that Congress has engaged in economic dragooning, which is personally my favorite word of all time. I love the word dragooning. It's so great. Economic dragooning that leaves the states with no real option but to acquiesce. In essence, the states allege the SALT cap will burn their taxpayers so heavily that states will be compelled to adopt ameliorative policies in response. But states have failed to show that the financial burden that taxpayers will result as a result of the cap is any more severe than the burden that might accommodate any other economic disappointment. In the end, Congress enacted its caps pursuant to its own broad taxing authority under the Constitution. The cap, like any tax provision, will affect some taxpayers more than others, and by extension, will affect some states more than others. But the cap, like every other feature of the tax law, is part of a landscape of federal law which makes states decisions as to how they will exercise their own powers. Because the states have failed to plausibly allege that the cap, more than any other federal initiative, meaningfully constrains its decision-making, the court has no basis for determining it's unconstitutionally coercive, and for the foregoing reasons, the government's motion is granted and state's motion is denied. So that is the case of the state of New York, Connecticut, Maryland, and New Jersey versus the U.S. government as it relates to the Tax Reform Act that we just discussed. So the U.S. government has put a cap on the dollar amount of deductions that can be given for local and state income taxes. As a result of this, the states believe that they will be pressured to lower their income taxes, and they probably will be. But as the federal government points out, and quite rightly, this is not an unconstitutional derogation. This is within the power of Congress to do, and it's not an unconstitutional coercion. And for that matter, the states don't have to ask permission, and they don't have to do this. They can continue to have any tax policies they like. Whether or not people will respond by moving out of their state or otherwise trying to avoid taxes, of course, is a whole other issue, but it's not a constitutional limitation. So on the whole, I think this is correctly decided, and correctly goes to show that Congress, when it's enacting its tax authority, can pretty much do what it likes, and this is not a problem constitutionally. So state of New York's, Connecticut, Maryland, and New Jersey may have to change their policies, But if they do so, it is their own free choice, responsive to their own constituents, and because it will most directly impact rich people, and rich people tend to vote and speak, one would imagine that policies will change accordingly. But whether that's the goal or not, it's well within the constitutional design, so no problem. And so that's all for today.